because the
Hi,
little bit of
everyone.
snow just, oh, sorry.
No, that's okay. No worries. We're going to start. So good afternoon. Welcome to Be the GC. Today, we're going to be speaking with Rita Heimes from the IAPP, the International Association of Privacy Professionals. And I'm really excited to dig into some issues with Rita. Please ask questions if you have any, put those in the chat box and we'll get to them as best we can. And if we don't, we'll follow up after the webinar if there are too many questions to address. So I'm going to very briefly introduce Rita. So Rita is currently the General Counsel and the Chief Privacy Officer of the IAPP. She started her career after graduating from law school in the early 90s at Beryl, and then went to UMaine Law School for a number of years and then transitioned over to IAPP. And I'm really excited to talk, Rita, with you today because there's a lot of unique things that you bring to the table. One of them is being the General Counsel with a very small law department, and but a large global nonprofit organization. So I'd like to start to talk about that, what that's like for you, the path getting there. So first of all, how is it being the GC and the only attorney within the organization?
Thanks, Gemma. Thanks for having me today. Maybe I could just describe the IAPP a little bit as what we do and also what it's like organizationally. So the International Association of Privacy Professionals is a membership association, much like ACC. We have over 60,000 members globally, and the folks who tend to join the IAPP individually as individual members are people who have chief privacy officer roles like the one I have, or they could be analysts or coordinators or managers, all with privacy responsibility, or maybe they're outside counsel or consultants who focus on privacy and data protection, cybersecurity issues for their clients. So it's a group of people who are incredibly specialized in doing privacy and data protection work, either in-house or outside their firm. And so we do what membership associations do. We provide a lot of content. We organize events that are typically live in normal years. We also offer certifications. So if people want to demonstrate their knowledge in the field, they can study for and take an exam and become a certified information privacy professional. Then there are flavors, US, Europe, Canada. We have CIPM for people who learn how to manage in-house, and CIPT for the technologists who do privacy on the side, privacy by design. So there are different flavors of certification that the IAPP offers, and of course you can take training to get prepared to pass those tests. So that's essentially the business of the IAPP. And so in terms of being large and global, I guess we're global to the tune of 60,000 people. But we're not a huge business in terms of number of employees. We have just over 200 people who work for the IAPP, the majority of whom are headquartered in our New Hampshire, Portsmouth, New Hampshire office. And we have a small office in Brussels, Belgium, which is our European headquarters. So that's what it looks like as a company. We've been organized as a 501c6, not-for-profit, from the very beginning, which falls under the trade association, but we don't lobby. We're a neutral, policy neutral organization, really designed to help people just do their jobs better and network with each other and learn how to be a privacy pro. And that's our mission. So I'm the first General Counsel. I'm the first Chief Privacy Officer, and all of these things have come along in the last 5 years, although the organization is 20 years old. The founder, if you will, or the first full-time executive director, now CEO, president of the IAPP, is Dreher Hughes, and he is a graduate of the University of Maine Law School, which is how we met because I was on the faculty there. And he was a chief privacy officer back in the late 90s when these sorts of jobs were just being formed. They were just starting to have CPOs. So the CPOs decided they should all get together and hang out with each other since they were forming a new and unique profession. So Trevor's a lawyer and a chief privacy officer and now he's my boss. So it's an interesting dynamic to have your boss know at least as much as you do about your work. But you can tell that the organization really grew differently. It didn't grow with the risk hat on, because having a CPO and GC is a late stage choice for a company that's now 200 people. So I'm coming in as someone who pays attention to risk and compliance within an organization that wasn't built as a risk and compliance fearful organization. Luckily, we've always cared about privacy. So I feel great about the kind of privacy work that's been baked into the company. There's still work to be done, by the way, but I didn't take over a mess at all. And of course, as a not-for-profit based in the US, there was very little comprehensive consumer privacy regulation that applied to the IAPP. Other than that, your privacy notice needs to accurately disclose what it is that you do with data. So it's amazing how you can take over a job that no one was doing before and find that there's all sorts of things that need to be done. There's no shortage of work. And that's where I'll stop and see if you have a follow-up question.
So I do, and it's interesting that you say that. My first in-house position was for a small startup, a software startup, and I had been representing them when I was in private practice, and they brought me in. I was the first attorney, the first GC, and I don't remember inheriting a mess, but I do remember really needing to prioritize, because all of a sudden I was there, so the budget for external counsel, presumably from the CEO's perspective, could go away, and here you go. So the question I have is, so even though we can acknowledge that you didn't really inherit a mess, what did you prioritize? So if you think about the first 90 days, what were the really critical pieces?
Priorities were established for me based on the circumstances of my role. I had been hired to be the director of research, and so I was brought in to be a subject matter expert in privacy and run our research team. This is coming from mostly an academic role as well as from private practice. So I kind of fell into more of an academic, thinky, researchy role with a lot of writing and teaching responsibilities. And then it became clear that the person who was doing privacy for the IAPP, we needed to upgrade, let's say. So GDPR, the European General Data Protection Regulation, was coming on board, and that made the IAPP subject for the first time, if you will, to a comprehensive consumer privacy law, other than, as I said, than the typical California, you must have a privacy notice law. And so it became clear that we needed to up our game internally. And Trevor said, well, Rita's a lawyer and a practitioner, so she could be our privacy person. And I became the in-house privacy officer, data protection officer for the IAPP and research director. So that just sort of, you prioritize at that point, well, we need to comply with GDPR, and you need to have a great understanding of all your data processing activities. You have to run it through the list of compliance questions. What is our lawful basis for processing this data, et cetera, et cetera. It very first and foremost becomes a transparency issue with your customers, which makes you have to learn what you're doing so you can be transparent about it. And then after that, the compliance issues come to you. You do not have to go looking for them, especially when your customers are privacy pros and are only too eager to tell you what you might be missing or what you need to catch up on. So really, GDPR compliance was my first real job. And then we had a sale of an asset that came to us. Someone wanted to buy something that we had been offering that was a separate product line. And that's when we needed a quarterback for that transaction. And our CEO said, I need a general counsel. So that became my priority. And it also became the reason why I took on the GC role. So that's the happenstance. That's just the in-house story, falling into a role that I never applied for, if you will, and just agreed to do. But it's just, as I said before, if you take a role that didn't exist, suddenly you realize, holy cow, there's a good reason why we now need to have one of these things. And it's been fun, but it's been one of the challenges, Gemma, is going from a specialist to a generalist while still being required to stay as a specialist. Because you can only absorb so much content, literally knowledge, in a day. And I have to say is one of the things that I'm trying to balance is how to keep up my privacy chops, because I still professionally need to have them while also negotiating random contracts and doing things that aren't, at all on point with that line of work. So.
And that it's interesting that you raised that, because I think that's a challenge that is present for general counsels, regardless of the size of the company, the size of your staff, your team, is really figuring out how to manage up, over, across, down. When you're part of a larger team and you're a member of the executive staff, managing that and still practicing law and still maintaining some expertise in the areas that you specialize in or drive you or you're passionate about, whatever it is. So that makes a lot of sense, and yeah, that is certainly a challenge. So I'm just looking at some of the questions. Let's talk a little bit of substance. And we were just talking before we got on, the impact of COVID to us personally and our professional lives, and being at home with kids and what have you. How has the last year impacted your practice from a privacy perspective? How have companies, your members, had to pivot as a result of the pandemic?
I would say two major issues faced everyone right away, apart from the obvious ones of just transitioning to being at home with families and having to manage that. From a privacy perspective, one was the impact on employees and the collection of employee data using platforms like video conferencing technologies and whatnot, and any other health-related data that employers began to collect about their own employees that they never had thought to do before, right? It never was an issue to ask people how they were feeling physically when they came into work, or to question. And so there's been, initially, I think there was a lot of grappling with how to deal with the privacy implications of contact tracing and health-related questioning. The other issue that faced people immediately in the privacy space was the fact that reviewing new technologies that were being deployed, sometimes instantly, like rapidly, for purposes of either doing work or offering work, offering your customers another experience. Our example is we went from having only certification exams that you could take in a building with a proctor to offering them online, just like all the bar exams did around the country. And that's a major tech platform shift. That's a major change in the delivery of a huge product, a stressful product, by the way, for your consumers. And luckily, we already had a relationship with a vendor that had that product to offer. But you have to quickly and yet thoroughly figure out what are the privacy and security implications of this new technology. So privacy pros around the world found that their workload went way up right away, and yet you don't have, you can't take these things lightly. They're just so important. You can't rush it. So we asked them in surveys, did you rush your privacy and security reviews? And I think, in May, people were like, yeah, sorry, we kind of had, the business necessity outweighed sometimes our ability to be super thorough. But we asked them again later in the year, in October, and we found that people had had enough time, a bit of a breather, that they could then go back and do a more thorough assessment, and that everything had adjusted so that there was no rushing anymore. People were able to do very thorough review of any new tech platforms and whatnot. So I think there was an initial spike of panic and a huge workload increase. And I do believe, probably like for most of us, sort of settled in professionally by the fall. Did you have that experience, Gemma? Did you feel like right away it was crazy and then it kind of got normal, or maybe it's still crazy?
For sure. Yeah, there were issues. Actually, I was reminded of what last March was like when, and this is true for members of the association and in my practice, really looking at how we manage data, how rigorous we were managing data, looking at our contracts. At force majeure was a daily, how many times have we looked at that as boilerplate, and then all of a sudden it was dominant.
Yeah.
And then earlier this month, with events in the United States, at least, we were looking at some of those issues again. You know, particularly on or around January 6th, all of a sudden, force majeure was a issue. So, yeah, you know, it's interesting I think for association members, as I've talked with them, being at home, initially there was some struggle, some difficulty, wondering when we were going to return back to work. There was a urgency to how we were practicing, and now we've settled in. So the question has become, you know, what is next? What does a return look like? When will there be a return? Will there be? I'm sure for some, you know, some of my members I've talked to have said, our members have said, I may not go back to the office. So you know, this whole idea of ongoing management of data and how we're managing data, I think will be an ongoing issue. I have a lot of children in my life, and one of them just took the GRE and did that remotely. And you know, how do you do that, man? So, yeah. All right.
This is off topic for our profession, but I think for a lot of people, for some people, it's incredibly invasive and incredibly uncomfortable because it gathers more personal data in the video environment than it does, obviously, if you go to them and just sit at a desk. But for a lot of people, it's such a relief. They love that they don't have to drive to some cold, weird place. I personally know someone who passed the bar exam because it was online. When it was live, it was hard for them. So it's a balance, you know.
Right, right. So I have a question here, and I want to paraphrase it. So the question is on technology for privacy programs. So how do those two interplay with each other, if they do? I mean, what's the role of technology when someone is either launching a privacy program or updating, adjusting? What do you think about that? I know that's a pretty broad topic, but let's delve in.
Well, I think what the question is, and I don't mean to misinterpret it, so hopefully they'll correct us if we're wrong, but we at the IAPP see what we hope we see, the entire privacy ecosystem and landscape. And it looks like the cybersecurity security landscape did in the 90s and early 2000s, which is to say, holy cow, there's a problem that technology causes, which is the vulnerabilities to hacking and other cyber incidents. And so there must be a way that we can also use technology to solve this problem, or at least to mitigate it. So there are all sorts of tools to check for nefarious activity on your servers and whatnot. Privacy is different because it's not so much about the invasion of your systems or building your systems from a technical perspective, but it's a slightly more like a compliance feature, and it is increasingly more like a compliance role. We have 60 jurisdictions globally that have privacy and data protection laws. So how do you keep track of all this, and how do you demonstrate if a regulator should ask that you have been keeping track? That's just one example. There's a number of requirements that you have to follow that are actually, you have to create records of things. So how do you document that you've done things like that? So we see privacy tech vendors blowing up in our space, people who invent new software and whole new platforms. OneTrust is a major example of this. They're now a unicorn, the first in our space to be valued at over $1 billion. And they've just developed, they're trying to become the standard bearer for having a tech platform that helps you manage all of your privacy programs along the way. And there are several others apart from OneTrust that either also have platforms or that have tools that you can use. So privacy supportive technology is a huge space. It is attracting all sorts of venture capital, and at our show floors, when we have them, it's just a scramble to be able to get the eyeballs of the people who have budgets, who are responsible for in-house privacy management. So if that's your question, I would say the use of technology for firms that are large enough and have large enough customer data sets to be able to afford and deploy these programs, everybody's shopping for them now. One obvious one that everyone on this call probably has had to deal with is cookie management, right? So cookies being those files that are placed on your customers' devices when they visit your site. And of course, you know, if you have anyone in the EU who's visiting your site, you need to comply with the cookie requirements. And you can't do that without a cookie management tool. So there it is. Someone creates a tool to help you manage this. And that's just one tiny, but I think well-known example of how tech is clearly now here to stay in our space.
So this next question is built off of something that you just said. At the beginning, you distinguished between privacy and some of the other cyber risks, you know, resiliency in the data space. How do you make those distinctions? Can you do that for us?
Oh, yeah. I mean, I do this every day. So for those of you who are not spend all your time thinking and talking about privacy, which is great, like there's a whole bunch of other law out there. Security is only one of the fair information practice principles. The rest of them are things like data minimization, don't collect data if you don't need it, right? And purpose limitation, which is make sure that when you collect data for a single purpose, you don't accidentally or even intentionally let that data be bled into multiple other purposes that are unrelated to why you collected the data. Transparency, explaining to your customers and data subjects why you are collecting their data and what it will be used for, and sometimes giving them control over what happens. So that might be in modern law, the customer's right to access their data and find out what you have about them. It might be their right to tell you to delete it because they don't want to do business with you anymore and they don't want you to keep their data after they are gone. They may ask you to be able to port their data from your systems to your competitors' systems, and a lot of privacy laws give them the right to take their data in electronic form and move it to your competitor, and that's the right of portability. So those are things that may have security implications, but they're not security. They're really privacy, data protection subjects. And it's just an example. One other common one is accuracy, data accuracy, the right that a consumer has to make sure that you have the accurate data about them, which is always in your best interest as well. So it's a mutual benefit. That may be part of integrity of data under security, but not necessarily purely an integrity question. So they're absolutely related and they touch each other, but privacy is its own domain with plenty of its own work to do and its own need for expertise.
So another question from that, and you and I had the honor of working with you back in 2018, along with Attorney Chris Hart and Attorney Cliff Nichols, to talk about technical competence, right? And what we're required as attorneys to know in that technical space. So here's the question: in the privacy space, for us folks generalists in that area or not, you know, subject matter experts, what do we need to know? I mean, it really, you know, being a contract lawyer, it impacts almost every deal that I negotiate at this juncture. What do I need to know about privacy just to be, you know, ensuring that I'm competent and helping my client?
Yeah. Ooh, I wish I was such a good expert at the tech side that I could just tell you, but it is a space that I always feel inadequate in. I have to just totally admit that. And I feel like my best response is to grab someone who does know what they're talking about and bring them with me. However, if it's just you, and occasionally it is, isn't it? We're all sometimes in it solo, at least to a point. The significant privacy issues that I encounter in a contract, for example, will be obviously agreement to comply with the relevant laws of the jurisdictions in which your vendor is, or your counterparty is based, and or your data subjects are from. You really need to have a decision of what that data, who the data is going to be shared with. So who are those other parties that will touch the data? And you need to have a deletion plan. What happens when we break up? What are you planning to do with the data? Those are all just the very high level major points of negotiation. And that's not even getting into their warranties about security and who's responsible in the event of an unauthorized access to that data or any other data breach or leakage, notification, all that other stuff. Where data is stored, both in terms of the structure internally that the company uses for the data, and as well as the vendors that they may use and the backups, like what sort of cloud services they're using for your firm's data. That's all super good to know, and you may over time develop a sense of comfort if they're using certain cloud platforms that you feel are gold standard in terms of their security, for example, or even just their privacy practices. And this is important because as consumers become more aware of their rights, they may ask you or your counterparty to delete data, and those requests have to be passed along the chain like a bucket brigade through all of the parties that may touch the data. So do you feel confident that all of the parties in the supply chain know how to do that and will do it if you ask them? That's not a tech question necessarily, it's an operational question, but you do need to be able to convince yourself that that's going to be the case should you enter into that deal.
Okay. So I read somewhere recently that almost half of the world's population at this point, and that statistic is going to just go up, are regulated by some privacy regulation. So what does that mean for the corporations, the members of ACC, and the companies that they represent?
Yes, I am actually reading right here because I have a slide that I printed from one of our presentations that we are saying by 2023, over 65% of the world's population will have its personal information covered by modern privacy regulation, and all of the major economic players, right, have, for the most part, have comprehensive consumer privacy legislation. Europe, Brazil, California. Eventually, the US, there is a prediction that we are closer than ever to a comprehensive federal privacy law. So for those of us on this call who are in the United States, that is huge news. What it means is if you don't already have people who at your company who understand and can speak the privacy language, you should find a few of them. And frankly, if you don't feel as though you fall under a comprehensive law, but you can see one coming in federal privacy legislation, then now's a great time before panic, to have a few people kind of get up to speed, and then you're ready. But what it actually means for companies that are already subject to these regulations because they have global customer base is that they have, since 2018 at least, since the GDPR came online, been trying to decide whether everyone gets GDPR rights or just the people in Europe, or everyone gets treated like the Brazilian LGBT or just the people in Brazil and California, etc. So my impression, and it's somewhat borne out by our research, is that for the most part, everyone went global right away and treated their customers under one regime, typically the GDPR regime. But over time, they've been able to become more sophisticated about offering mix and match of certain kinds of rights, pick and choose. And that's part of the maturation and sophistication of an enterprise dealing with customers all over the world. So I think that it will continue to evolve. It will continue to be, for the next 10 years anyway, an area that you will have to invest in, and you just can't avoid it. The fines in Europe are huge, and I suspect that if you fall under any forthcoming US regime, there'll be some teeth to those laws as well.
So we're going to move back to sort of practice and career management questions. As a first-time general counsel for a nonprofit, how are you finding the community, and how do you interact with some of your GC members? And I think the question is, do you have GC members that you're interacting with, and how does that go?
Not GC members of the IAPP that I'm super familiar with, because privacy, based on what I just said, has become a full-time career path for many, many people. I do see the combination of associate general counsel and privacy officer. Sometimes you see GC CPO at tiny companies like mine, but largely, many of the people who belong to the IAPP work for major companies in which they don't have to play like 3 or 4 roles at the same time. So I can't speak to having a lot of GC friends. I would love some. But I mean, I'll just say, and I'd love to hear from the people on this call what they think, Gemma, if they're writing in the chat window. It was not an easy decision. I mean, in some ways I had no choice, right? The CEO said, I need you to do this. And I said, okay, right? That's just what you do. But my immediate boss, who has a law degree and an MBA and is a privacy expert, he just said, like, be careful that you don't give up an expertise that is more transferable, right? Because everybody needs a privacy officer at some point, or maybe some big companies have lots of them, but there's only one GC, and not every company has a GC. So are you putting yourself in too narrow of a category while also diluting your expertise? It's a great question. And it really makes you think, well, what's my next step? And do I even have one? Because if I'm at my last job, I can do this and there's no harm, right? But if I think I want to move again, where do you go as general counsel? Do you become another general counsel, or can you slide back into the hierarchy somewhere else? How do employers look at you once you have the GC title? Is it with respect or with like a pigeonhole? I don't know.
It's interesting that you say that. I was actually talking with my manager this morning, who I adore. I'm very happy with my current employer. But I was saying, I was a GC. I've been a GC twice. So I was a GC, then I went back in the ranks, and then I was a GC of a large international company, and then I'm back in the ranks again. And so I was saying that I think sometimes I forget that I don't have the level of authority that I would if I were GC. And I like that most of the time because it just allows me to really focus on practicing law. But there have been occasions where I've taken a position with my internal clients or with a counterparty that maybe is a little bit more strident or a little bit more authoritative than I should. But in talking about that this morning and processing, it was really my own sense of insecurity. It really wasn't anything that I was doing wrong for the bank. It was just me adjusting to having been a GC and now not. So at least in my experience, Rita, having bounced a little bit and actually now being very, very happy where I've landed, I was able to leverage what I've done to land in a spot that I'm actually really content and truly hope will be my final position in my in my career. In any event, so it's an interesting thing. I think too. I'm going to bring this in. I don't know who is in the audience from a sort of a demographic perspective, but what I have found in mentoring young women attorneys and other folks is that a lot of folks today are defining success very, very differently. And for me, having reached the pinnacle, the so-called pinnacle of my career as a GC, it reached a point where the travel and the time and the responsibility was not working. So I needed to take a step back. So that's part of it too, right? Like where are your priorities? So.
Yes, my commute is down the stairs instead of an hour down the road on I-95. So it's great. Like I was telling my husband yesterday, instead of getting in my car at the end of a stressful day yesterday, I got in the shower. Like that's nice, but I don't know how long I can keep this up. So.
Right. So let's go back to substantive law. What do you think about global privacy programs? Are they possible for some of the companies that are represented here on the program? Can you do privacy globally so that there's one program?
Oh, yes. For a smaller company, it might be the only way to do it. And there's many advantages to it. For one thing, for the most part, there's a set of principles that's settling in. So the California Consumer Privacy Act, while having a few interesting nuances and definitely a challenge to interpret here and there, for the most part, is based on many of the things that the GDPR set as the table. And so is Brazil's LGBT, common core principles with a few nuances here and there. So most of the nuances, for the most part, can be addressed in your privacy notice if you feel like, oh, go over here to check this out. Maybe with the exception of the do not sell obligation that the CCPA has that no other law has, where you have to give people the right to opt out of the sale of your data and place it prominently on your website. Those are unique. And so assuming you have done the analysis and you do fall within CCPA's sell definition, that would be an exception to the global system. But I remain fairly optimistic that you can essentially build a single system. The caveat, of course, is that there are definitely some restrictions, especially when it comes to the use of data for marketing, that the GDPR places that is not the case under US law. Right now, US law is a little bit more liberal about being able to reach out to people without explicit opt-in consent, about things like cookies, which are unique to the e-privacy directive as interpreted by the GDPR's consent provision. There's some things that you quickly stumble upon. Having a global policy can be very restrictive. And so then you have to decide, am I having a global policy because I think that's the right thing to do? Am I doing it because it's the only way I can figure this out? Or do I feel comfortable abiding by the law of the jurisdiction in which my customers live, my legal obligations? And you do have at some point to make those decisions, and they're in part business decisions, not just legal ones.
For sure. So we have another question here. This is a good question, and it's a couple of parts. So I'm going to read it, and then we can break it down. What are the key practices for law departments trying to, A, build a privacy program, manually do data mapping with no budget, okay. And then build a culture of privacy?
Yes.
And I can refresh if you want to take. So the first one is, what key practice tips for building a privacy program?
Yeah. I mean, I really enjoy working with law-trained people in privacy, especially given that this has gone from a fairly straightforward notice and consent system in the US, opt-out consent, fairly straightforward, very generic privacy policy in which you do not promise that you will never lose their data, right? That, like we've gone from just having a good privacy notice to far more sophisticated and intense responsibilities and new law. So I have a bias for JDs in your privacy team. And so if you have some who have a little time on their hands, get them involved in the IAPP. You can, even just for free, we have a lot of resources, get up to speed, register for the daily dashboard, start getting to know the language. That would be my number one recommendation for building a privacy practice. And maybe it is part-time right off. And then use outside counsel as needed for, the unique and hot button issues like is this a sale, and how can I structure my relationships with my counterparties so they are not considered to be the sale of data, so that this is a service provider versus a third party. So now I'm getting into the technical. There you go. That's why you need a lawyer. The technical language of the CCPA. It really is a pretty intense legal analysis. So I'd start with that. The second question was, data mapping. This is impossible to do with just a law degree. So now I'm flipping my sentence. Do not try to do data mapping without your data science team. They actually know where data is, and they know where it's stored and where it comes from and where it goes. They know, they're trained in data flows. So I kind of pretended to do one by interviewing a bunch of people, and I had a kind of a good idea where the data was, and it was good enough for describing it for our privacy notice. But to really know how it works, you gotta have a data scientist or a whole bunch of them who work with you. And if you already do, you should be, you should know them by first name basis, their children's names, their spouses, partners' names, their pets' names. You should be that familiar with them because you should be working with them all the time. And I guess the last piece is it's usually the marketing team and the tech department generally that will be your other friends. because that's where the hot buttons are in terms of data usage. But that's just the tip of the iceberg. Yeah, data mapping and inventory is best done by non-lawyers, in my opinion. And then the final question was data culture of privacy. And that's a hard one because I came into an organization that has privacy in the title of the company. So we are inherently aware of this subject, and everyone gets to go to our events. All the staff travel to our events. And even if they're standing there with the sign to help people find the restroom or the food, they pick up privacy through our members and through conversations and through just being in our environment. So it's a fabulous place to already try to start a privacy culture, but it still helps to break your communications into small groups. So get invited to the department meetings, and the smaller the department meeting group you could, like, the more you can break it down into job role, the better. Get yourself invited and have conversations. Figure out what it is that they do that touches data that makes a difference from a privacy perspective, and engage them with a simple lesson about, like, just bring one or two things that you think they should know and that maybe they could do differently. And just start with that. And that will get them to know who you are and hopefully like you and feel comfortable with you and trust you. And then they'll just ask you questions. And that's the best you can do, because you don't know what you don't know, but you want them to spot issues and come to you with questions as they see them. So I like to break it into small pieces and develop relationships that way. And I think that's the best way to start building a culture of privacy.
Yeah, you know, it's interesting. So I also work for an organization that it has a privacy culture, but from talking with folks, I just recently had someone compare it to the area of intellectual property, where you have executives and peers outside of the legal department who in fact don't know what they don't know, and sometimes think they know more about what can be a very complex and sophisticated subject. And presumably, you know, it's privacy. Like, yeah, we all know a lot about privacy, but in reality, the regulations, the legal construct, the complexity is not well known. So trying to break it down into some plain, digestible nuggets, that's brilliant, Rita. I think that really, and starting to talk about it in a way that key people within the organization are going to grasp is probably a great first step, and, you know, sort of spreading that into the culture. So we have another.
Just
Yeah,
one quick thing, because I said this yesterday, and it's probably complete, because I was on a short interview that was all about privacy culture, and I had to come up with like 30 minutes of content on just this one subject. So one of the things I said, which I was not sure we've even implemented, is if you could do it, I think it would be cool to get HR to ask privacy related questions in interviews of new job candidates, to seed from the very beginning, hey, what do you think about this? And if your job involves data, you know, we're an organization that takes this seriously. How do you feel about that? I mean, from the beginning, like, to introduce this before they even join you, because of course at the onboarding stage, you're going to want to talk about it again. And then you're going to want to have these small group meetings routinely. But wouldn't it be cool if privacy could come up before someone comes to work with you?
Yeah. So I'm going to transgress. We've got a couple of questions, but I'm going to transgress for a minute. As you know, when we were doing the sound check before the program, my daughter set off the fire alarm right before I was going to go live. So I sort of panicked a little bit, and I went downstairs and I scolded her and I said, you know, I'm about to get into this discussion with Rita, and we're, you know, what, Mom? And well, we're going to talk about privacy. Who cares about privacy? Like, really? So, right.
Not everybody.
There's a set of the population who really, you know, because she shares everything everywhere. So I love that idea. I think that would really be helpful to have a sense, as people were coming into an organization, what their views were on this very interesting subject. Okay, so this is someone in-house in a compliance legal role with a default specialty in privacy due to internal need. Do you have any advice on how to best educate internal stakeholders on investing in privacy for the organization, both in terms of time, personnel, and software? So how do we convince our non-legal counterparts that they have to invest in privacy?
Well, it would depend, to be honest, on the industry in part. It depends on the scope of your customers. Where do they live? And so it also depends on what it is you're selling them. If you sell items that once they're installed, refrigerators, not smart ones, just dumb ones, you never see these customers again, then you probably have a relatively benign amount of personal data that you collect on them. However, if you are online enterprise where all of your business is done through the internet, and or you are in an industry where trust is absolutely crucial, like financial services or insurance services, they probably don't need to be convinced. You have such a high risk, not only in terms of the liability issues, but just in terms of losing customers to a organization they trust more. I would assume that would sell itself. So I think, I would hope that fear isn't the driving motivator for your management to look at privacy. I see it actually as a great way to retain good employees and good customers. Doing privacy well is a good corporate value, and it makes other employees feel like they work for the good guys. So it's just like, if you work for an organization that is cavalier about personal data, cavalier about customer privacy, treats all data as their data, not the customer's data, and just does whatever they want with it, that bleeds into the corporate culture, and it feels like the organization can't be trusted, and the customers will ultimately figure this out. So why not do it right? Why not educate ourselves, figure out how to manage data in a responsible way, just like we would take advantage of having sustainability practices or diversity and inclusion initiatives or other important ethical and socially responsible issues that create a culture of feeling like you work for the good guys. So I would start with the feel good stuff, but if you need help, we have all sorts of resources on the bad things that can happen to you if you go against privacy compliance.
Well, we actually have a question on that. So, we've been talking about preventative, but the question is there a best practice for what to do when the privacy horse has left the barn? In other words, when you've had a failure.
I think it's never too late to try again. And frankly, sometimes a thing going wrong is the best lesson, so I don't look at these failures as the end. I see them as the beginning, to be honest, because look, IAPP can hardly say it does everything perfectly. Not at all. We're always doing it better. And it starts with understanding what happens with the data when you collect it, literally where it goes and who touches it and what they do with it. Then you identify the vulnerabilities in that and the risks in that. You hopefully mitigate them. Usually that's by reducing access to the data and or having a really good plan for getting rid of it when you're done with it. And you tell your customers what you're doing. Like, that's the simplest version. So no, I don't worry about a failure. Just learn from it and fix it as quickly as you can.
I think that's what the person posing the question is trying to get. What do you do to fix it? So in other words, we're in a situation now, Rita, where we've had a failure, right? As a legal department or as legal personnel, what do we need to do? How do we manage that internally, externally? What are some key steps to take?
I think admitting it to a customer is always better than pretending that you didn't. So assuming that the customer knows you've had a failure, then you're going to have to be honest about it. But, you have to choose your language carefully. Since I don't know the facts, I'm totally making this up. I mean, if it's a breach situation, we all know that you just have to fix that as much as you can. But you also want to determine, is this an internal issue? Is this happening with the people who are engaged not getting it? Is this something the tech department can fix with a different program or a different tool? Is this something that the people who are on the ground day to day just need to change how they practice? They need to do things differently. I don't know, but you have to investigate and get to the root cause of the issue and then fix it from there. It's probably a bunch of things that are all interconnected, unless it's something that happened 20 years ago and you just found out about it. In which case, there's not much you can do other than apologize and hope that it never happens again.
You know, I was in a discussion with one of my mentees about a week ago, and so I'm a big advocate of having really plain language in contracts and having clean drafting. I like to really promote that. And we were talking about notice. You know, if a vendor, if there is some release of personal information, PII, or there's some sort of small breach and it's impacted one of your customers, when does the vendor have to give notice? And there was an argument first about using the word immediate versus prompt, and then the time, you know, so 2 hours, 6 hours. And finally, I said to this attorney, I guess I would really question using a vendor who is arguing with you about whether they have to give immediate notice of release of PII or prompt notice, number one. And if they're bickering over, you know, having 24 hours as opposed to 6, I mean, let's not mess around here. Let's so again, that is more on the preventative side, but it seems to me that as we're forging relationships, you know, for some of the larger corporations on the phone, you know, look at who your vendors are, look at how they're managing, if they're getting PII, how they're managing it. It really is a pretty complex web. You know, and I'm with you. I mean, if something happens, you've just got to own it. Like there's no, you know, in my career, there have been some instances when legal and the communications team and the marketing team are together and they're figuring out how to manage some reputational risk. And you, of course, you have to do that. But in something like this, it's really ensuring that the customer understands, hey, we screwed up.
Yeah, and just, I hate to say this too, but sometimes there's someone who is in a position to frequently communicate on behalf of the company or make decisions or handle data, and they're just not doing it, right? They're just not doing it right. If you can't get their attention with whatever authority you have, it's important that you go over their heads and fix it, because these issues just you can't continue to let them slide. You have to fix them.
Right. Okay, so we've answered the questions. Rita, I have one more thing that I would like to ask you from my notes. And again, going back to being the GC, what's your favorite part? What are you enjoying about your current role?
I like seeing everything, right? It's such a view into all these pieces of the company that I never got to see before, because I sign all the contracts, so I see what each department is working on and selling or buying. I like being invited to the big kids table to have conversations about strategic direction. You know, those were always past the conference room, and I saw all the big kids in there having their super secret meetings, and now I get to go. So those are the little emotional pieces that are maybe a little the child in me who just likes to be included. So yeah, that's good. I mean, it comes with responsibility, of course, but it's also one that the longer I do it, the better it helps me at doing that comprehensive work. You know, that I am both eyes and ears because I see all these things. And I also can, you know, bridge between the strategic direction and, you know, the deals that we're doing or the other problems that are coming up. So I feel like I am a connector, whether I'm supposed to be or not. And I also just want to say one more thing, and I hope this is true of me, but I do think that it's important that people feel comfortable working with you, because you need them to communicate when things go wrong or when they have a question, and being accessible and not scary and, you know, not too proud is part of being able to communicate with both the senior leadership and also all the other people. And again, I'm speaking as someone who has to play so many roles because our company is so small. I hope I'm good at that, but it's definitely one of the most important qualities I think that I have to bring to this job to keep these two sides in balance.
Yeah, I agree with you completely. I mean, being a trusted advisor, being approachable, being a connector is really a key to success in this role, because you do want people to come to you both with great, exciting news and with the bad news.
Right.
And I have found too in my, in the various roles, that having a sense of sort of not calmness, but being an even keel, really ensuring that I'm not overreactive, or I don't come to too quick of a decision.
Gemma,
Important.
one more thing, and this is a feature of growing from a small company into a bigger one, and I'm sure some of you can relate to this, that the growth is partly what creates the need for the role, but one of the reasons you need the role is perhaps senior management can't do it anymore, right? They need to offload some of the things they used to do all the time. So that's great, because it gives you responsibility that they used to have, but it also means that the atta girl or atta boy or whatever isn't coming from the person that used to give it anymore. Right? Everyone used to love the praise from the CEO, and maybe that person's too busy. So you kind of also have to pick up the praise feature, because you represent now someone who used to be there, more intimate connection. So anyway,
So Rita, it's really been a pleasure. The hour went by very quickly. I was surprised to get the notice that we're wrapping up here. So folks, thank you so much for listening. Really appreciate it. If you have any further questions, please feel free to reach out to me and let me know. Please check out the website for upcoming programs, or our social media outlets, both Twitter and LinkedIn, and you can see what's going to be happening within the chapter in the coming weeks and months. So Rita, once again, thank you. It's been a pleasure to spend this time with you, and we really appreciate your perspective and hearing your views. Very, very helpful. Gemma. Thank you. Take care, everyone.